Cool. All right, welcome everyone. Today is Friday, March 17th, 2023. We are on voting list number 17. Actually, number 14. Number 14. Tomorrow, today is the 17th. We are on voting number 14. All right, we're going to start off with Senate Bill 351.
Give me 1 second. I'm just my computer.
Sure, take your time. Josh, are you ready for Senate Bill? Okay, all right.
All right, Senate Bill 351 establishes the Affordable Life Wills and Estate Planning for Seniors program within the Maryland Legal Services Corporation to provide seniors with low to moderate financial means access to affordable civil law related services. Beginning December 1st, 2023 and annually thereafter, MLSC must report to the governor and the General Assembly on the implementation and utilization of the program. The governor must include a $500,000 appropriation for the program in the annual budget. The bill takes effect July 1st, 2023. As amended, the appropriation is lowered to $225,000.
So the amendment just lowers the appropriation, right?
Yes.
We adopt the amendment? Everyone's good? All right, Senator Carter.
I apologize for this, but I just have a question, because I know that legal services provides a lot of low bono and pro bono work for people. Is this an area that they simply already don't cover, or are we just supplementing an area they already cover? If you know.
I don't know what other services in terms of this specific area they cover. Senator, I can look into that.
It's okay, I just was curious. Thank you.
I had a question.
Sure, Senator Sidnor.
Oh. And if and correct me if I'm wrong, it could be confusing it with another bill. But did legal services ask for some sort of an amendment to ensure that they stay within their charitable purpose to this? Is this, or am I mixing it with another bill?
There wasn't, and I didn't receive any other amendment requests. I know in the testimony, or at least in the written testimony,
Okay, so it must be another bill. I'm
there
thinking
was
about.
a request for the eligibility to be modified, but I didn't receive any.
That's what, okay, that's what I thought I remembered.
Amendments that align income eligibility guidelines with current Maryland Legal Services Corp guidelines. But
That's
guess we
what I
don't have an
thought I
amendment for that.
remembered.
Is that what the amendment does?
We
But
don't have an
no,
amendment.
the amendment just, that changes the budget.
This is in the Maryland Pro Bono Resource Center testimony.
Favorable.
Well-
I just moved the amendment.
Oh, yeah, right, that's fine.
Move favor.
Again, I'm not against it. I just wanted to make certain that we don't cause no problems for them, based off what I thought they said.
I don't think this is a problem. I think they just want, they want different eligibility levels.
Right. In the pro bono.
I think it wasn't just that, I like this bill. I talked to the sponsor. I suggested she make sure we had the amendments because I really like this bill and want to work with her on future ideas like this. But my recollection is the problem about the income eligibility was that if we didn't align it, and there would be some problems with, I wish I could find my notes, some problem with the ability of it to go forward and for this bill to work with the existing entity, isn't it? Which was the existing entity that she was gonna work with. The Maryland Legal Services Corp. Isn't that it?
This is the program.
Yeah. I swear they needed amendment so that would work.
Yeah, they put in that they wanted a payroll with a sponsor and that's. But it's not the amendment that was put in.
They needed the income adjusted so they could do this program.
Do you want me to print it?
You got it?
Yeah, I got it.
Okay.
Match their own. Executive guidelines.
Right.
That's what Windows.
So there's, I'm sorry, there was, okay.
I was gonna ask easy question. It does have a mandated appropriation. Is it a shall or a may? So I know they're moving from shall to may. Must. Okay. Thank you.
So there was a second amendment. That was my apologies. There was another amendment, and that amendment does change the eligibility criteria. And so if you don't have that in your packets, I did not print that for your packets. I can print that out now, and if we can come back to it, I can.
Said that now, he said, found the one for pro bono research.
The sponsor said he was fine with that. I asked him.
Okay,
And no change. I don't want to speak out of line. I want to make sure that I spoke correctly. It's still like a must appropriate. That wasn't changed in any amendments that aren't presented.
the other amendments actually was asking for an increase in the appropriation and doesn't change the must language.
But so it went down, but must is still this.
The amendment that I first explained just changed the appropriation to 225,000.
It's
still a must.
It's still a must, a shall. Yeah, thank you.
We're gonna go on to Senate Bill 507, Senator Muse, and that's Jamie as the counsel. Thank you, Mr. Chair. Senate Bill 507 increases from 5 to 10 years the time after which a court is required to dismiss a charge of first-degree murder or a crime considered sexually assaultive behavior against a defendant found incompetent to stand trial. A victim or a victim's representative has a right to petition the court for extraordinary cause to extend the time to dismiss the charge against the defendant found IST for a crime of violence if the victim or the victim's representative has submitted a written request to MDH for notification or submitted a victim notification request form. There are no amendments in your voting packet. So just a little bit of background on the current law. Prior to the repeal of the death penalty in Maryland, capital crimes were subject to the 10-year limitation. When the death penalty was repealed, this was taken out. That is, I think, a point of contention and has been for a couple of years with this bill as to putting that language back in. But that's been the issue. Whether or not the current offense would be considered a capital offense, because that's what it was originally when pre-repeal of the death penalty.
Never mind.
I couldn't find my file, and this hearing must have been a while ago on this. So as I read the language of the statute, whether or not the defendant's confined, the court will dismiss the charge against the defendant found incompetent to stand trial for first-degree murder or for a sex crime after 10 years, right?
If they're found incompetent.
If they're found incompetent at the time of trial, as opposed to when the crime was committed, right?
Let me read to you the standard for IST. So by statute, a defendant is incompetent to stand trial if the defendant is unable to understand the nature or object of the proceeding or a system defense.
Right.
So it's focused on the trial, not NCR, which would be not criminally responsible.
But there's a difference between the date that the crime was committed and the date of the trial. So to be indicted for first-degree murder, I would assume that the time the crime was committed, there must have been some competence because the person decided on a premeditated version to commit murder, right?
You can't assume that. It could be the case that a person's not criminally responsible at the time, it's not determined yet. And then later on, it's a separate issue if when the time the trial comes, whether they're competent to stand trial or not.
Well, that's at the time of trial.
Right.
But
Completely
in order,
I think you can't presume what their responsibility or competency was at the time of the act.
how can a person who's incompetent and can't understand what he's doing form the premeditation necessary to commit a murder in the first degree? If you're incompetent, you can't, how can you determine in a premeditated fashion to commit murder?
I don't
think premeditation requires the amount of planning that you think it does. Premeditation simply requires forethought. So if you were to go upstairs to grab a gun and then return to commit a murder, the act of going upstairs, choosing to get the gun and coming back downstairs to murder someone would fall under the definition of premeditation. It doesn't require an extensive amount of planning ahead of time to commit the murder, days or weeks ahead of time. As long as there is a conscious point at which you could detach yourself from what you're trying to do, then there's premeditation. And so you don't have to be completely with it in order to make enough plans to go upstairs and get a gun.
So a person is simultaneously has enough competence to get a gun and to plan a murder, but is incompetent to stand trial for having gone upstairs, gotten a gun and committed a murder. And so if somebody falls in that position, this bill would let them off the hook after 10 years.
Instead of 5, which it presently is.
5 years, if that's the way you want to characterize it.
Oh, okay.
It's
All right.
10 years, not 5. Pushes it back to what it was before we did the death penalty and things dropped off.
All right. Last question. Why wouldn't this apply to other crimes? Why is it only applying
Oh my
to
God.
first degree murder and,
I'd be glad to come back and look at that. This one up.
Does so this, as I'm understanding, sex offenses and what he was talking about with the more serious offense, does it have any impact in here? Regardless, and I'm asking because I haven't looked into it far enough. Does it have any effect on if they dismiss that, their requirements to be on the registry, sex offender registry?
I think I need to look into that for you. Off the top of my head, I couldn't tell you.
Yeah, I just don't see it in here, and I'm kind of curious because they did note a specific case where the person was coming up on 5 years and had been convicted of 2 sex offenses, one including sodomy. And then, those are pretty serious allegations and offenses against someone. And I would like to think that we would still ensure that they would remain on that registry, because that type of offense makes them a lifetime registered sex offender, correct?
Excuse me. Yeah, depending on the offense, you could.
That's all. I mean, I would need to know that. I would feel much more comfortable knowing if it was going to be if
But-
that was going to be affected by
But
this.
I think lifetime registration would, again, I really need to look, because I can't tell you. off the
Yeah, and
top
I
of
don't
my
know
head.
the answer to
I
that
think
off my head. Off the top of my head.
lifetime registration is going to require a conviction. So,
They do require it, but if we
Right.
dismiss it, or if we vacate the conviction,
well, it's not, there's no conviction to vacate in this instance. What this is basically they've been charged, but trial
Incompetent.
hasn't progressed. They've been found incompetent. So for 10 years, under this bill, for 10 years, the charges would basically be pending until such time as they regain competence.
but does I guess, okay, so, but would they still be required to register and maintain that?
Even pending that, my gut tells me no, but I don't want to commit to that because I really just would need to look into that more.
Yeah, I mean, that's something I would definitely think that,
Right, I generally think it would require a conviction, but again, I need to look into that.
okay,
Rather be convicted if the bill was passed.
all right, thank you.
If you're determined not to be a danger, after being found IST, like you could be released on bail, right? So, under the bill, sexually assaultive behavior means an act that would constitute a sexual crime under Title III, Subtitle 3 of the criminal law article. That's where the bulk of sex crimes are in the criminal law article. Would also include sexual abuse of a minor under 3602 of the criminal law article, sex abuse of a vulnerable adult, and violation of certain provisions of federal law, or violation of another state that's equivalent to any of these offenses.
Been a motion for a favorable and seconded. Do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
yes,
Senator Muse.
Yes.
Senator Folden.
Yes,
Senator James.
Yes.
Senator Washington.
Yes.
Senator Kelly.
Yes, although the newbies are still a little confused as to what's going on. I'm trusting you all here.
Senator McKay.
Yes.
Senator Carter.
Hey, not just the newbies. I want to
Pass
make
yourself.
sure that we're talking about the murder and the first degree sex offense.
Well, so it wouldn't necessarily be
not
first degree
first
sex
degree.
offense. It could be any sexual crime under Title III, Subtitle 3 of the criminal law article. So sexually assaultive behavior means an act, and I can pull this up in Alexis, means an act that would constitute a sexual crime under Title III, Subtitle 3 of criminal law. That's the bulk of sex crimes in the code. Sex abuse of a minor would also include sex abuse of a vulnerable adult. And then any corresponding or equivalent crime from another state.
So what about like degrees, like first
but
degree, second degree?
Yeah, we're talking first degree, second
could it-
degree,
it can encompass both?
3 and 4, yeah.
I know. So I don't think I don't think that should be the case. 10 years to determine competency.
Well, so technically it would be the lesser of 10 years, or you could go to the max like you couldn't take it past the max.
Oh, you couldn't take it past
possible
the maximum
sentence.
time they could be incarcerated.
Right.
I think it's a year.
I want to say that's a year.
So that's for any offense. It couldn't extend beyond the time they could have served if they were found guilty. Is that correct?
Right, and I'll just read you the text of the law. So when charged with murder in the first degree or sexually assaultive behavior after the expiration of 10 years or, oh, you know what? All the existing provisions of law say the expiration of the number of years or the maximum sentence for the most serious offense charged. This does not include that language, so it would be after the expiration of 10 years. So,
Could we add that?
You could.
Senator,
oh, sorry.
would you mind adding that? I think it's important. If you have something that's only possible that you could serve for a year, because it's considered a misdemeanor and it's not a more serious offense, to hold 10 years over, the same as if it was a murder charge, I think is excessive. Would you mind an amendment just to add that language that,
I don't think it does any harm to it. It makes,
Change it.
I mean, I don't want to change the bill.
don't change the bill, but just make sure that the period to await potential trial for incompetence, it shouldn't be 10 years if the maximum you could have ever served was 1 year.
No, right now it's 5 years.
Yeah,
So
but
we're
that's for the
actually taking it
serious
up.
ones. We don't want to
Right.
change that. Like for the serious ones, you could serve life.
Right.
So that's not affecting it.
Does
But
that-
the way the language is, according to what he said, it also encompasses the lesser, like a 4th degree sex offense.
Yeah, so the maximum penalty for that is 1 year right now.
I didn't want to see every time and every- before they agree to the amendment, so. Can we?
Facts, if we do that, it makes sense in concept, but I don't know what other like secondary like consequences there are. If you put that in the code.
Amendment,
Yeah. And not, well, I really don't know. Push it out.
I think we do need the amendment. I'm not sure, whatever else it affects. So if you're talking about crimes that where a person could serve life, 10 years is not unreasonable. But if it's
Yeah.
much less than that, it should not go beyond what the maximum time the person could serve. It just shouldn't.
With Senator Carter, and if we come with an amendment, I'll put it on the floor. But let's just get it moved.
The vote is open. We consider the vote. But you got, it's 9 to 10 to what? 9 to 0 right now.
Well, actually. Senator Washington says he wanted to.
yeah, it just goes down to 7.
This isn't, no, I am in support
No,
of
no,
the
no, I
bill
know.
in concept. We can't put out a bill that does that, you all. We gotta change that one part. Jamie gave the language. I mean, are you comfortable with that?
You may, I'm comfortable with this, but you make a good point. So I'm not.
You're comfortable with it?
But you make a good point. So if you want to, we're going to hold the bill then. Bill gets held. And you guys are going to figure it out before you're done. Are you,
Why do we have to hold the bill? Can't we just,
We have to vote to amend it on the floor. Why are we holding the bill? We got,
This is
we're
so
I
already in the voting.
agree. If I am happy with the language you suggested, amend it on the floor, don't hold the bill, but seriously, you can't do,
strike, run again. Run this bill, run the roll call again. It seems like 3 or 4 people are going to change their vote afterwards anyway, as long as you don't change the results. So
well, I think we're good if we could amend the bill with the
I just
language.
don't know what the other consequences of that amendment are. I can't, I'm not even like, I'm not,
Bring the amendment to the floor.
and then you have more time to research it on the way out.
serious charge. So I think, I don't understand what issue there is.
You can still offer it on the floor and it can, and,
No, do it now and move the bill. Do it now
okay, fine,
with the
okay.
verbal approval of the
Okay.
amendment.
Verbal approval, what is it?
So conceptually.
Yeah.
You just want me to restate what the amendment will be?
Yeah.
So conceptually, it would be to the existing language, I'm just looking at the existing law right below it. It would be after the lesser of the expiration of 10 years or the maximum sentence for the most serious offense charged.
That makes sense.
Sure. So Sandy, it would be after the lesser of the expiration of 10 years or the maximum sentence for the most serious offense charged.
Does everyone understand that?
Yes.
With amendment.
Second.
We gotta do roll call again.
No, everyone's good. Unanimous.
Jill has that thing.
All right.
Or just, I just think it's appropriate for us all to just listen to each other, because I think we come up with some great points and we can start moving some good bills, so.
Go
Well,
us.
no, we voted first.
We voted first. I'm like,
Right.
maybe I guess we'll vote. Okay.
Thank you.
Okay, so Senate Bill 351 establishes the Affordable Life, Wills, and Estate Planning for Seniors Program within the Maryland Legal Services Corporation to provide seniors with low to moderate financial means access to affordable civil law-related services beginning December 1st, 2023, and annually thereafter. MLSC must report to the governor and the General Assembly on the implementation and utilization of the program. The governor must include a $500,000 appropriation for the program in the annual budget. The bill takes effect July 1st, 2023. And so that first amendment that I had given you would lower the appropriation to $225,000. The next amendment I gave you would delete provisions related to the eligibility determination in the bill and just refer to the provisions already set out in 11-603 that are set by the MLSC in determining eligibility. And so if you look on page 2 of the reprint, the provision of services under the program shall be in accordance with this title. And so it's deleting that part about the age and then the family income level. And that's it.
No, it's not. So here's the deal. Problem is, we adopted the amendment that dropped the language, the number down
Correct.
first.
So
So
the other amendment was asking to raise the number to 750,000.
it seems like this amendment's asking to do that.
Yes,
Yes.
this
Okay.
amendment.
So the other amendment, so how do we do this now? Because we've already dropped it down by adopting the other amendment.
So I guess in principle, we
So
could
the-
adopt the second amendment that I gave you and then,
No, we have to do this one first.
Yep.
oh,
So we're gonna have to recall the other amendment we adopted, consider that, adopt this and then adopt that one.
got it.
All right. So the move.
So why are we reconsidering it for we were raising the amount, but what's the other part of the language that we're?
Nothing, the other amendment we did, drop the number.
Yeah, I know, but I'm saying on the new one, what's the language, other than trying to increase it, what does it change?
The eligibility.
Aligns the income eligibility. with
Oh,
the
okay.
existing
Yeah, yeah, yeah.
program.
Okay, yeah. That perfect. Perfect. Okay, very good. Perfect. So yes, I agree. Recall.
The vote for the amendment, what was the amendment number?
Yeah,
Amendment,
I give it to you. It's amendment number, it's SB 351/213-928/1.
is everyone okay with that?
Yes.
So now the bill is original and the motion is to adopt amendment number 143-628/1. Okay. Everyone's okay with that? All right. Yes.
And I just want to make certain that we're doing this right. In the amendment that's before us right now, that amendment increased the appropriation to 7,500. So with, very good. I just want to make sure, okay, thank you.
But the second amendment, the language isn't right. It's right, it's, the language is wrong. But it says specifically that you strike out 500,000 and put 225.
It does, and we're about to do an amendment to take the number down to 250.
But
Yep.
Let's go. Yep. That's great. Exactly.
Okay, so then now the amendment is to Shamari on page 3, lines 2, just strike
the language.
750 and add 200, and what was the number? 225 or was it 250?
225.
225. Is everyone okay with that?
So we're gonna, he's modifying that amendment.
Yes.
Perfect.
All right.
He just changed.
I know, but I just have a question. I just want to make sure, as I said, I fully support the bill. I'm going to work with the sponsor on another matter very similar, but I just want to make sure that budget and tax has been consulted and we'll have kumbaya.
We can spend up to $250,000 without their approval. So this comes under
Right. Thank you.
25,000 under.
Perfect.
All right.
How many times can we spend 200?
Yeah, well, that's the question.
All right, right on.
Yeah, let's get some 250.
Second, is everyone okay? There's been a motion been seconded. Is everyone being recorded in the affirmative? Senate Bill 351 with amendments passes unanimously. Okay, Shamar, we're going to stick with you. We go to, actually, sorry, that's Josh. We're going to go to Senate Bill 653.
Senate Bill 653 alters the definition of neglect in statutory provisions that govern child in need of assistance proceedings. The bill specifies that neglect does not include the use of cannabis by any parent or individual who has permanent or temporary custody or care or responsibility for the supervision of the child, unless as a result of the use of cannabis, the child's health or welfare is harmed or placed at substantial risk of harm, or the child has suffered a mental injury or been placed at substantial risk of mental injury. No amendments.
Thank you. This is a good bill and I've voted for in the past. I just wanted to understand if it's in the same posture wording wise as it was when we've passed it previously.
Yeah, there is a one-word difference to the bill that was passed last year, which is the bill last year referred to the mere use of cannabis.
On only that one, no,
RE,
yeah,
just, no, I was answering Ariana's question. Oh, okay. I thought you asked me. I'm sorry.
yeah, that's the word. Move favorable. I don't think, well, I don't want
I don't want to be noted as opposed.
All right. Okay, being recorded in the affirmative, absent Senator Fulton. Okay, so the bill passes 10-1. All All right, now Shamari, we are going back to you just with Senate Bill 403.
Senate Bill 403 specifies that mandatory property insurance for condominiums as required by existing provisions must generally cover the common elements and units for attached or multifamily dwelling units only, and the common elements only for detached units. The bill makes other alterations to requirements regarding mandatory insurance for condominiums, including further specifying provisions that are applicable only to attached or multifamily dwelling units. The bill also exempts detached condominium units from a certain requirement to include specific information in a condominium declaration. So there is an amendment, it should be in your packet, and that amendment requires the owner of a residential detached unit to carry homeowner's insurance on the entirety of the unit.
Move the amendments.
Well, let me just, certainly any intelligent person is going to carry homeowners insurance, but I own my house, my mortgage was paid off. I don't have to buy homeowners insurance if I don't want to. Why are we going to force someone within a detached condominium unit, which is very much like a detached house, to buy homeowners insurance if the person doesn't want to do it? I think they're dumb not to do it, but do we really want to force them to? And if we are, why don't we require all homeowners in the state to buy homeowners insurance on their homes?
Insurance companies would love it, but I just leave it as it is, you know, they couldn't afford it.
We do require all car owners or leaseholders to buy car insurance. This one's different.
Car, you're gonna crash into somebody else and hurt somebody else. In a home, it's just your house. And if you're dumb enough not to buy it and your home burns down, it's your own damn fault.
Sheesh. All right.
Yeah. Yeah. Yeah, that's what I'm talking about.
Well, that was the amendment I was talking about. I don't know about the underlying bill. Where did the amendment come from?
All right, hold on.
Bill, which requires the condominium to own insurance on all common areas. So, you know, if the common area burns down, you'd want it fixed so the people in the individual units 3 stories up in the air don't have to walk through a burnout lobby in order to get there.
Then if we make them purchase it and they don't purchase it, there's gotta be some mechanism to hold them accountable on, or
I'd propose stripping the amendment, leaving the bill intact. Again, where does the amendment come from? Who submitted the amendment and why?
So this was, I believe, a request from the sponsor to, give me a second to just check my email.
let them put it back on the floor if they want it, but let's move it. Move the bill without the amendment.
Right. Move the bill with no amendment.
We'll strip the amendment in. Second.
Yes, it was a sponsor requested amendment to conform with the House amendments.
So it was the house's fault, huh?
There they go again. What's up, all of that?
No, I have that.
You got it. Okay.
And so apparently this amendment was agreeable to all parties and requested by Maryland Legislative Action Committee.
Community Associations Institute.
Association for Community Associations, CAI. Yeah, I know who they are.
Can we do what he said?
That's all they do. It's like a trade association. That's why they did. They don't like that.
Then do a conference committee.
Yes, that's, yeah,
I agree.
Yeah.
second.
Wait a minute.
No amendments, naked.
Okay, did you check that vote?
No, we're about to take it right now.
Okay, just making sure, sorry.
Do you want to roll this? Is everyone okay?
Yep. Okay.
All right, unanimous. Conference committee it is. Yeah, Senate Bill 226.
So Senate Bill 226 prohibits a person from knowingly or intentionally accessing with intent to view child pornography. An individual who is charged with violating this prohibition has access to existing affirmative defenses for the offense of possessing child pornography and is subject to the existing penalty provisions for that offense.
Because I want to make certain that we're knowing what we're doing.
Which is.
The text?
Please.
So the existing law, and I'll just pull from the bill here. A person's prohibited from knowingly possessing and intentionally retaining photograph or other visual representation showing an actual child or computer generated image that is indistinguishable from an actual and identifiable child under age 16 engaged in its specified activity. So this would take that provision and say that a person couldn't knowingly or intentionally access with the intent to view those materials.
That are in the bill for viewing child pornography of a child that is recognizable to be under that age.
Actual or computer generated, that's based on an identifiable child, right?
Oh, okay.
Well, Senator Sidner, then Senator West, and Senator Kelly.
So, and the reason I'm just saying, just slow it down and make certain that we know what we're doing is I know we've passed laws in the past where juveniles were sending or sexting or sending videos of themselves. And they've been prosecuted. So let's say, for instance, one of our, a parent sent us something saying, hey, is this your child? And the video could be considered to be pornography. I knowingly accessed that video with the intent to view it, right? So I mean, am I now being prosecuted?
So I guess is the hypothetical that you either, well, I think in that hypothetical, you're intending to view
Right.
the image.
Right.
So you're intending to access it.
not
It's, but not for, you're possessing it or viewing it for a purpose that isn't, I guess, prurient. It's not like motivated like that, but you're just looking at it to see, is this, my child that's depicted here?
Does it have to be prurient under it?
No.
So I'd be kind of caught.
Would it technically be a violation?
Yes.
Yeah, I could see how, because you've intended to
Right.
view that. It was your intent to view. It's on the one hand, like, is there a crossover there too with access? Because that's what the prohibition is accessing. And I'm just sort of thinking out loud here. Possession, there are defenses to possession. But I don't know, I'm gonna kind of need to think on that one, like, because that doesn't sort of
Right.
go with prurient intent.
Right.
Right.
Okay.
Why don't we add a 3-word amendment to the bill that says a person may not, comma, with prurient intent, comma.
I'll be, okay.
Does that solves
That's all.
Charles's problem, and I think it makes the bill better. So
With
prurient.
I know I'm gonna butcher the pronunciation of this.
Prurient,
Prurient, would it be interest as opposed to intent?
interest, that's fine.
okay.
Interest, that's fine. Sure.
Intending to drive some sort of fun experience.
Exactly. The bill.
Oh, how much constructive I can add to this conversation. I was, as I was listening to Senator Sidner reading the Office of the Public Defender's letter. I don't know, again, I am super new to these issues, but as a mom, certainly have been experiencing what is hard for a lot of the parents of teenagers with the whole, they sext and send videos, and I can't get over it. But nonetheless, the last paragraph, not my kids, just to be clear. But the last paragraph of that letter gives an example of 16-year-old in Charles County who was charged, prosecuted, and convicted for sending a video of herself to 2 friends. That situation and abuse of discretion at every level occurred in the state less than 10 years ago, blah, blah, blah. And then it says teenage sexting is not child pornography, but until the legislature changes the definition of child pornography to teach teenagers who sext is entirely different from adults, blah, 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 we run this risk. So I think what I'm understanding is that the prurient intent amendment intends to address that, but would not a teenager in that situation have prurient, how do you say it, intent?
The difference between prurient and non-prurient intent is that basically the
purpose is.
the purpose is sexual in nature. I'm trying
So
to
this
think of
wouldn't
a better-
protect our teenagers who are sexting
doing
at
it
all.
as like a dating, an aspect of dating. No, that probably would be with prurient intent.
We need to exclude the, I'm sorry, but children are stupid and foolish, and no matter how many times you tell them not to do stupid, foolish things. And I worry about the kind of the things that Senator Carter raised earlier about, putting children at risk.
So, the bill prevents the streaming of child pornography. Currently, downloading is illegal. So streaming is not illegal. Number one, I think we need to get back to what the bill is trying to do. Number two, we've already created a separate part of the statute defining the governing of sexting, which I think then takes care of the question of children being stupid.
That's not what the letter says.
Yeah.
And let me just pull up the provision of law. That was in response to INRI SK a couple of years ago, but let me see if I can pull up what actually passed. I could just get a minute.
Ah.
All right, we're gonna hold the bill because the bells are ringing and we'll come back, not today, but on Monday. So we're done with voting for now. We'll see you on the floor.
So just